Thank you for joining this MBL webinar on copyright and AI. My name is Mark Linsner and I'm a senior associate at Bristows. I specialize in intellectual property litigation, particularly disputes concerning trademarks, copyright, and design rights. Today, we will be reviewing some of the most recent legal developments in response to the challenges posed by the ever-growing prevalence of artificial intelligence. Since this is a rapidly developing area, our focus will be on developments in 2025, but we will look back to the end of 2024 on certain issues. The rapid growth of AI, in particular generative AI, has brought new legal issues to the fore and raised debate around the application of established principles of copyright law. Some of these legal principles are being reconsidered at statutory level with the introduction of new legislation or reforms of existing legislative frameworks. Other issues are being left to the courts to decide on an incremental case-by-case basis. To reflect that, this webinar is organised into two sections. The first section will look at some recent policy and legislative developments in the UK and EU, and to a lesser extent the US. The second section will consider some recent judicial decisions and highlight some cases to look for on the horizon. We start close to home by looking at recent policy developments in the UK. As things stand, the UK government has not enacted any new copyright legislation to address AI and has not yet amended the existing legal framework. Even so, the issues posed by AI have been on the government's agenda for quite some time, and the key issues have been canvassed in several reports, inquiries, and consultations. At a statutory level, one of the key areas of debate in the UK is whether the text and data mining exception in Section 29A of the Copyright Design and Patents Act is fit for purpose in an AI world. Most recently, in December 2024, the Labour government published a consultation paper on copyright and AI. The government considers that the current UK copyright framework does not meet the needs of the UK's creative industries or AI sectors. The consultation outlined a number of fairly bold proposals for changes to aspects of the current law. A selection of the key proposals are on the slide alongside the three core objectives underlying the government's consultation. Our focus will be on the UK's proposals for the TDM exception. We do not need to look at the text of Section 29A in detail. The key point is that the current TDM exception is very narrow in scope and applies only to text and data mining of lawfully accessible data for the purposes of non-commercial research.